Did the government amend the Constitution just to keep the DPP Paula Llewelyn in office? Well, that was one of the arguments being made on day 4 of the Court of Appeal hearing into the DPP Retirement Age Case. What were the arguments? Stay tuned. People who said government is inefficient should look at what happened here. That was what was said by Mike Hilton, Queen's Counsel. He's representing opposition politicians Philip Paulwell and Peter Bunting in this case. What did he mean by that? He was talking about the way in which this Constitutional Amendment Act was passed, and I'm going to get to that in just a little bit. Now, Mr. Hilton was trying to convince the judges today that the Constitutional Amendment Act that was passed to raise the retirement ages of the Director of Public Prosecutions and the Auditor General, that was passed for an improper purpose. And he said improper purpose didn't mean fraudulent. It didn't mean that there was anything immoral going on. It just meant that something was done which was outside the scope of what was allowed. Now, Mr. Hilton says the undisputed evidence is that the government passed this act for the purpose of extending Ms. Llewelyn's time in office beyond which the Constitution would have allowed. What does he mean by that? Well, to explain that, we have to just back up a little bit. I know you've heard some of this before, but stay with me. It's important to remember it so you understand the arguments he's making. So February 2020, Ms. Llewelyn had written to the Public Services Commission and asked them to extend her time in office. She was supposed to retire in September 2020. She got a 3-year extension. And then in 2023, again, she wrote to the PSC in February asking for another extension. They said, no, the Constitution doesn't allow for a second extension. Now, Mr. Hilton says in that same letter in which they told her you can't get an extension because the Constitution only provides for one extension, he said the PSC also said we are going to start the process of looking for a new DPP. But he said that never happened. He said there's no evidence that there was any advertisement. There was no evidence that there was any attempt to start a search for a replacement for Ms. Llewelyn. Instead, what happened was that we got to July 25, 2023, when the government brought the Constitutional Amendment Bill to Parliament, debated it, and passed it in the same day. Leader of opposition business in the House, Philip Paulwell, said he wasn't even at Parliament on that day because he didn't know this was going to happen. The bill went to the Senate on Friday, July 28, 2023, and the same thing happened. It was debated, table debated, and passed in the same day. And then the next working day, which was Monday, July 31, it was signed into law by the Governor General. This is what Mr. Hilton meant when he said to the court, anybody who thinks government is inefficient, just look and see what happened here. An amendment to the Constitution passed in less than a week. So he also said that an opposition senator had made a proposal, say, hey, why don't we push this bill back until January 2024 and pass it then, when Ms. Llewelyn would have already left office, would have already reached the retirement age, reached the end of the extension and retired. And he said the government just ignored that, refused to accept that, went ahead and passed the bill. So Mr. Hilton is saying that the dominant reason, the dominant purpose for the government passing this act was to allow Ms. Llewelyn to get an extension in office, which she couldn't get under the Constitution because the Constitution said no more than one extension. All right, so that was him trying to persuade the court that the government's purpose in passing this Constitutional Amendment Act was to benefit Ms. Llewelyn by giving her this extension in office. But he then now has another hurdle to clear. Was that, even if that was the purpose, was that an improper purpose? And he is arguing it was an improper purpose. Why? He says the Constitution lays down a process for giving an extension to the DPP. Because that process couldn't be followed because she had already got one extension, he said Parliament now was going around the Constitution to try to give her an extension. As a reminder, what the Constitution says is that for an extension, the Prime Minister should consult with the leader of the opposition and then recommend to the Governor General that the DPP get an extension. That's what had happened in 2020 when she got the 3-year extension. Again, because the Constitution doesn't allow for more than one extension, the Parliament, Mr. Hilton is arguing, pass this law to go around the Constitution, as I've said, and give her this extension. And he's arguing that that was an improper purpose. Mr. Hilton also told the court they should look at the entire context. So he said, for instance, look at the situation with the Auditor General, because remember, this act raised the retirement ages of both the DPP and the Auditor General. He said nobody has been making a fuss about the raising of the retirement age for the Auditor General. Why? She hadn't reached 60 yet, and therefore there was no concern about the effect and the purpose of the legislation in relation to her. Now, the judges had quite a few questions as to why it was that Ms. Llewelyn shouldn't benefit from this Constitutional Amendment Act. And I should say they've been asking these questions, since yesterday, since Mr. Powell addressed the court, asking them of Mr. Hilton as well. I don't get the sense that they're entirely satisfied with the answer. The answers have been along the lines of the fact that the act isn't retrospective, it's not backward looking, and that Ms. Llewelyn, I beg your pardon, couldn't benefit because her time had already run. She had reached retirement age, she had got an extension, she shouldn't benefit from the act. But we'll see when the ruling comes out. It could be they're just testing the lawyers and testing their arguments. Now, King's Counsel Ransford Bram, yes, now the King's Counsel Ransford Bram is also representing the government. So he responded now to Mr. Hilton's arguments. And essentially he was saying this improper purpose argument doesn't hold any water, dash it away. Obviously, my words are not his, but here is what he did say. So first, on the point of Parliament trying to go around the Constitution, Mr. Bram said no. He said Parliament has the authority to amend the Constitution, has the power to amend the Constitution, and they were acting within their power. So he is saying, no, there's no problem there. So one of the things Mr. Bram was arguing, he was saying that if you follow Mr. Hilton's arguments, then it would mean that even if one of the sections of the Constitution, that's what they call deeply entrenched, the most strongly protected provisions. He's saying if Parliament was trying to amend one of those provisions and doing it in the way the Constitution said, with a 2/3 vote in each House of Parliament with a referendum, he's saying if all of that happened, the court could come in and say, well, this wasn't passed for a proper purpose, so we're striking it down. And he said that would turn the law on its head. He said what Mr. Hilton is trying to do is introduce a whole nother tier into this process, a whole nother level into this process of constitutional amendment. And he said the court cannot go down that road. So one of the judges, Judge Leng, asked Mr. Bram if he was saying this improper purpose argument should be restricted. Mr. Bram said restricted? No, eliminated. He said it has no place in this particular case. It has no relevance. It has no applicability. Dash it away is what he was essentially saying. But he went a little bit further, and that's something lawyers will do if you're arguing a case, because you want to know that if the judges don't necessarily agree with you on one point, you have another string to your bow, you have another argument. So on the one hand, Mr. Bram is saying the court should not accept this argument that they can strike down this particular act because it was passed for an improper purpose. But he went further, as I was saying, and he was saying, so even suppose it's true that Parliament passed this law to benefit Ms. Llewelyn, Mr. Bram is saying there's nothing wrong with that. He's saying the Parliament passes laws all the time to benefit private entities or individuals, entities like churches, entities like railways. They'll pass private bills to benefit them. So he's saying there's actually nothing wrong with that, even if Ms. Llewelyn is the intended beneficiary. The judges were saying, Can you really compare the DPP with a church, with a railway? Mr. Braham said the essential point of that argument is that there is nothing wrong with passing laws to benefit private individuals as long as the Constitution isn't breached. So just to make the point that Mr. Hilton's argument is that there is a breach because he's saying the improper purpose issue is a constitutional principle. So Mr. Hilton is arguing that there's a breach. So that's what we're going to have to wait to see where the courts come down and what they decide on that. Going to be really, really interesting reading. Going to be interesting to hear when this particular ruling is coming out. The hearing is nearly at an end. So we'll just be talking about wrapping up and giving an overview for the final day of the hearing. Going to have to leave it there. Thank you so much for joining me courtside. See you next time.